mindful of any electronic devices. There's apologies from Alban, Patsy, Sean and Tom. Yes. And I don't think Mr Wells will be here either. Minutes of the last meeting are available for members, and if you're content with their accuracy, then I will sign them accordingly. Agreed. Thank you. Forward work programme for May to July of this year is on pages 13 to 22. It's been drafted to reflect last week's discussion at our informal meeting. The Department has highlighted two further changes to that programme. The SL1 briefing on the Injury and Duty Scheme, which was scheduled for the 25th of June, is now taking place in September. The EU Forward Work Programme, the 6th written update, scheduled for the 20th of May, is the same as the written briefing that was scheduled for the 18th of June on EU Justice and Home Affairs biannual report, and therefore it will be removed. The Lord Chief Justice has indicated that he's willing to expand his discussion on the 4th of June beyond the judicial appointments process if members wish to raise other particular judicial issues. At our meeting on the 20th of March, the committee agreed that we would raise the issue of lenient sentencing for animal cruelty cases with the Lord Chief Justice when he next attends. So if members can consider any other judicial decision relating matters that you would like to discuss with the Lord Chief Justice, he's coming up to do with the judicial appointments process, and then he's agreeable to widening that discussion. So at this stage, animal cruelty sentencing is certainly one topic for conversation, but if members can consider for next week any other areas for discussion, we can raise that with him. One of them, I think, would be useful is the review that he set up to do with consistency around a whole range of sentences. I think it would be useful to get an update from him on that. But if there's any other particular ones for next week, if members can think about it, we can put it on the agenda. Also, the arrangements are being made for Daniel Greenberg to deliver the legislative workshop to the committee to coincide with the Fair, Faster Justice Bill scrutiny, and that's assuming that the bill is introduced in May. The proposed date for the workshop will be Wednesday the 25th of June at 1 p.m, and the committee meeting will then commence at 2:30. If members are content then with the updated forward work programme and proposed date for the legislative workshop, then we can agree to that. Agreed. Other items in the tabled pack is additional information relating to the Legal Aid and Coroner's Court Bill. Departments provided further information that was requested by the committee regarding the delay in bringing forward the provisions to make the Lord Chief Justice the President of the Coroner's Courts, and provided a copy of the hearing schedules which show with the track changes the legal aid legislation as it would appear following enactment of the bill. And an updated bill timeline has also been circulated. The motion to extend the committee stage of the bill to the 20th of June is scheduled for debate in plenary next Tuesday. Item 4 then is the Youth Justice Review, changes to custodial arrangements for children. Officials that are here want to come forward. Pages 24 to 83 is the relevant section of your meeting folder. This is in respect of the response to the consultation on custodial arrangements for children and the Department's proposals for the way forward. So let me welcome Karen Pearson, Deputy Director of the Reducing Offending Division, Paula Jack, Chief Executive of the Youth Justice Agency, and Ciara Lloyd, who is Head of the Youth Justice Unit within the Reducing Offending Division of the Department of Justice. You're all very welcome to the meeting.
Thank you.
As usual, we'll record this formally on Hansard and then that'll be published in due course. So Karen, I think I'm going to hand over to you at this stage.
Chair. As always, we're grateful to have the opportunity to brief the committee on the outcome of the consultation on custodial arrangements for children in Northern Ireland. And as you said, Chair, Ciara Lloyd and Paula Jack are with us, and we're happy to take any questions. Members will recall that the consultation was launched in October 2013, and the consultation sought views on the development of legislative proposals to take forward the recommendation in the Youth Justice Review that all under 18s should be removed from Highbank Wood Young Offender Centre and placed in the Juvenile Justice Centre at Woodlands. We're focusing today on sentencing arrangements, And that might seem a narrow focus when considered alongside the needs of victims and witnesses and of safer communities. So we'll be very pleased to take any questions on the operation of the Woodlands facility under Paula's leadership and the type of work that they do there with young offenders to help them rehabilitate and resettle. We also start with two key principles: that sentencing of young people to custody is vital in the right cases and in the right circumstances, and that having the right sentencing framework is also important for public confidence as well as decision taking. The recommendation to remove under 18s from Hyde Bank has been achieved administratively, and no children have been in Hyde Bank since November 2012. Legislative change is required to regularise that position and underpin it in statute. So alongside that key principle, the consultation process looked at how this should be embedded in legislation and at some related matters. I should mention at the outset that many aspects of the consultation focus on what we have termed less serious offences to distinguish our proposals from existing arrangements for the more serious offences. So all of the disposals, including community disposals at one end of the scale and custodial disposals for violent and sexual offences or grave offences at the other end of the scale, weren't included in the consultation process. The consultation ran from December 2013 to January 14, and we received 26 written responses, and many of those were informed by the views of children and young people and their families. We also had 6 public consultation events over the period, including 2 events with parents' groups. And on the basis of the views received, a consultation summary of responses and a way forward document was developed, and I think we have that in your briefing packs. The proposals which the Department is putting forward are as a result of this consultation and are grounded in the recommendations of the Youth Justice Review, the International Framework of the United Nations Convention on the Rights of the Child, and the policy, practice and experience that's been built up over the years of operating a separate justice system for children. Children have always been recognised as having particular needs and vulnerabilities for which the adult criminal justice system is not best placed to provide. The biggest shift in emphasis over recent years has been in adjusting the system to recognise that young people aged 16 and 17 are children and as such need to be accommodated within a framework and at a location which provides age-appropriate arrangements for them. Another big cultural shift has been the change in the sentencing trends for younger children. The system itself has identified that the nature of custody is often unsuitable for younger children and is unlikely to encourage and support them in a way that helps them to change their behaviour. And we note the extremely low number of young children in Woodlands over the past years, and we can give some figures, Chair, if you wish. And in this context, I'd be happy to summarise for the committee our proposals, which are then set out in more detail in our paper. In summary, the Department intends to repeal the Juvenile Justice Centre Order in its entirety and the Young Offenders Centre Order as it applies to under 18s, and to replace both with one new order for all children. The new order would have a minimum sentence length of 6 months and a maximum of 2 years, although there would be an enabling provision to extend this to 4 years for 16 and 17-year-olds in certain circumstances. It would also incorporate a custodial community split with no more than half the order to be spent in custody, but the judge would determine the exact split to be applied in individual cases at the point of sentencing. But as a minimum, we propose that all children sentenced under the new order would serve at least 3 months in custody. Once released for the community part of the sentence, the child will be subject to supervision with the Youth Justice Agency and the Probation Board working closely together. And any breach of the supervision element of the order will be brought before a judge for a hearing, with the ultimate sanction being a return to custody for any duration up to the remainder of the original order. The Department is also proposing to remove children aged 13 and under in relation to less serious offences from the scope of the new order. I would stress that all other disposals, including the possibility of detention under other sentencing options, would be retained for children aged 13 and under. The new order would be prefaced with a reference to the spirit of the 2 key UN Convention on the Rights of the Child principles in relation to custody, so that a judge would be asked to bear in mind when making a custodial order that the best interest of the child should be a primary consideration, and that custody should be seen as a last resort and for the least period of time. Transitional arrangements would also be put in place to ensure that a child would not automatically be removed to Hydebank on their 18th birthday, although an upper age limit of 18.5 would be established at Woodlands. And following 18 months of successful operation of the policy to not hold children in Hydebank Wood, the Department has concluded that an exceptional circumstances clause is not required. Chair, that's a quick summary of the proposals. There's a lot of detail in the paper. We'd be very happy to take any questions.
Okay, Karen, thank you very much for going through that issue. Let me just start with a couple of questions. In terms of the children aged under 13 will be excluded from the scope of the new order, meaning then no child under 14 could be sentenced to custody for committing less serious offences. And obviously I note what the serious offences refer to, such as violent or sexual under the Criminal Justice Order 28. But what are the less serious offences? What are those type of offences that you're talking about?
Would it be helpful if Paula illustrated by reference to some real cases, obviously confidentiality around the child, but to illustrate the sort of offences that might be relevant here?
You're quite right. In terms of the more serious offences, the proposals here don't include relating to those. So if you were talking about serious indictable offences, provisions that currently exist would still apply in relation to those. For the less serious offence, there have been a very, very small number of children who are 13 and under who receive custodial sentences. And the types of offences that we could be talking about are multiple repeated assaults of a low level, or potentially in relation to assault on police, for example, if there is arrest for multiple care home issues where there's been assaults within a care home of that nature. But it's low-level type offending where perhaps custody is seen as an option but shouldn't be, because at that age there are perhaps better disposals for a young person of 13 and under who is in a situation of offending at that level, who could be better helped in a community disposal with the right help from both health, education and justice.
Do you have the figures for when you say it is a very small number? How many is that?
Yes, there were three in the last 5 years. And they were actually 13, so we're not talking about any 10, 11 or 12-year-olds as well. And
how long would they have been put in custody for? Do you know that?
None of them received more than 12 months.
In terms of the Hydebank and no under 18s being kept now at the YOC, and I think you'd say that that's been the case from November 2012, obviously there had been a suggestion that the exceptional circumstances would be kept, but you're now deciding that that's no longer necessary. On what grounds in the last 18 months has given you confidence that you wouldn't need to legislate for something that's very difficult to ever predict, so therefore it's exceptional? So why would we not do that?
Again, turn to Paula based on Paula's experience.
The proposals that have been put forward here are based on the evidence of what's happened in the last years since we've been trying to do this. Whilst November 2012 is the last time that we actually had any 17-year-olds in Hydebank, the work had been going on for quite a period before that to remove the 17-year-olds from the Hydebank Wood and into the Juvenile Justice Centre. So basically we're basing this policy on the evidence that we have from a number of years, and Woodlands is the best place to deal with young people of that age. And if we look at the facilities that we've developed, we've improved our educational facility to look at more vocational training in terms of future rehabilitation of that age group. And also we are in the process of developing a forensic medical team, which is vital for some of the young people that come in with challenging difficulties with their mental health. So Woodlands will be the best place to deal with any of these issues, and it's really about detention in a location as opposed to the need to move them for any behavioural reasons to Hydebank. There will never be that circumstance.
Has there ever been a case over the last 18 months where someone has presented a real challenge and you've got close to saying, I don't think this individual can be kept here at Woodlands, we need to send them to Hydebank?
To answer your first part of that question, yes, we've had some very challenging behaviour, and that's not necessarily 17, that can be at any age. But in terms of do we feel we need to move them for that reason, no, it won't be about behaviour, no. And I think that's an ethos that we've developed over the period of time that we were working to achieve the Minister's aim that we remove 17-year-olds from the Highbank prison in line with UNCRC principles. They shouldn't be detained as adults. And it's about making sure we've got the right regime, the right ethos, and the right way to deal with any aged young person who presents with challenging behaviour.
So as things stand, there's no circumstance that you can ever envisage someone being beyond capability of being retained in Woodlands. You can't envisage any circumstance where it could be exceptional.
At the moment, no, Chair. No, we think we can cope.
Okay. Thank you. That's me. Ms. McCauley.
Charlie, and thanks very much for the presentation. I suppose in very young people like that, the main purpose is to do the ultimate to prevent reoffending, so that those young people won't then enter the main criminal justice system. What strategies are utilised to prevent reoffending?
Is this with children in Woodlands?
Woodlands, the younger children.
If we're talking about younger children, the aim will be to keep obviously the Woodlands in terms. If, for example, this policy was to come into effect in legislation, one of the things that we've introduced anyway in the Youth Justice Agency recently as a new policy is what we call intensive support and supervision, and that's for all age ranges. And the idea behind that is that when we assess that somebody is at high risk of reoffending, we will put as much resource into that young person as we can to make sure that we do all we can to support them with our partner agencies in the community. For example, a young person who is given bail in relation to a number of offences and, as you rightly say, to help them desist from offending. We will work as hard as we can with the programmes that we have and with putting that intensive supervision onto that young person to help prevent reoffending. Within Woodlands itself, I think you mentioned in terms of that, we have a wide range of rehabilitation and resettlement programmes for these young people, and we always work very hard with them whilst they're in there in terms of working to address what is the cause of the offending behaviour, and also to look at needs as well in terms of release from Woodlands, to look at rehabilitation, reintroduction into the community and resettlement, helping with education and employment and all of those issues. We have a wide range of programmes that we work with young people. And highly qualified staff too.
Maintain as well, very important.
Okay, so given that in some cases, well, I'm trying to think about the difference between Woodlands and the YOC. So you might have somebody 17 and a half in Woodlands and somebody 18 and a half in the YOC. What would the main differences in terms of their experience of being in those places be?
I suppose the big difference is Highbank is a prison, and it's there for the adult population, really young offenders over the age of 18. Under the Minister's policy, it's just a very different regime. It's a very different physical setup, very different style of engagement. And although fantastic things are being developed in Highbank as well, that's appropriate to that age group, whereas Paula's younger people are smaller setting, geared up for their particular needs as children.
I think it's also quite key as well that the staff in the Juvenile Justice Centre at Woodlands are qualified in terms of social work, and that's the regime that we run by, and with full education facilities in terms. I know Highbank are developing a lot of new facilities, but in Woodlands the regime, by the rules under the Juvenile Justice Centre rules, is you will attend education even at 17 and a half, all day, Monday to Friday during the school term.
Okay, just one last question. In terms of the community part of a sentence, how successful is that? Do you find that people end up being brought back into custody, or does that generally work out?
It's a mix, it's case by case. I don't think we've got stats with us on that, but we can provide them.
Sorry, we have knowledge of recall, so we know what a 17-year-old who breaches YOC order, for example, or a young person who breaches JJCO, the numbers are incredibly small, very, very limited. But they are in the past few years, for example, Probation Board have told us that in 2011-2012 there were 7 orders, probation orders, which were breached, and there were, in 2012-2013, breach proceedings were initiated in respect of 4 orders. So, as you can tell, the numbers are incredibly low for under-18s.
Both probation and youth justice work with the young people who are released from custody to supervise.
And sort of looking at it long term, going back the ways, how do your figures nowadays compare with what, say, might have been the case 10 years ago? Looking at how successful maybe the strategies that you're employing are now?
In terms of having young people in custody, there are very, very few young people in custody, and what we're seeing now is a trend towards, in any event, the vast majority of our population being the 16, 17-year-old range in any event. So in terms of working with that younger age range, there's many interventions that are multi-department involved to work towards that intervention at an early stage to prevent offending and re-offending. So we'll see, over the years how effective those strategies are, but it is good to see that the custody population is at the higher young age range, the lower age range.
Thanks.
Thanks, Chair. Thanks very much for your presentation. Can I ask, are you happy with the organisation in terms of the target you have in reducing prospects, these young people reoffending? Are you on top of it, or do you think more can be done?
I think, I always say more could be done. I think the broader range of partner organisations we can bring in to help. So, for instance, last time I was here, Chair, I mentioned that we were working very closely with the Department of Health on a joint health strategy, which will cover this population as well. But yes, there's a lot already going on, as Paul has outlined, within the Woodlands facility, and we'll always be on the lookout for additional things we can add to that suite of interventions for the children.
Yeah. In relation, you mentioned health. In relation to drugs and drugs problems in the state, can I ask how many young people would you have in residence at a given time in both of the institutions you've mentioned?
I can only speak for Woodlands. Yesterday, I think, Paula, we checked, and there were 39 children.
The normal figures for Hyde Bank Wood are normally around 100.
So 39 for
Woodlands.
And Hyde Bank Wood.
Around the 160, they tend to hover around the 160 mark in Hyde Bank
Right, so
Wood.
they tend to stay in around that. So that's not to do with capacity, that's just the way it is.
It's just the overall numbers.
Okay.
Hyde Bank 18 to 21, be around the 160 mark.
And what's the ratio of staff then with working, for example, in Hyde Bank Wood with young people?
Hyde Bank, I don't know. We could find that out. That would be a question primarily for the prison service.
Okay.
We can write.
Can I ask, in terms of Woodlands, do you have a drug problem there?
If you mean, do the young people involved engage in behaviour that relates to drug offending and to drug taking, then yes, I think that's endemic in terms of the population within both prisons and youth justice, in that there are drug-related issues for offending behaviour. We don't have a drug problem inside Woodlands itself. But we do have challenging behaviours with young people who've come into Woodlands who have engaged in drug taking, who may need quite serious and challenging medical interventions to address their behaviour and their offending behaviour because of their drug taking issues.
Because obviously the Minister has admitted that there is a drugs problem in the wider prisons estate. That doesn't exist in Woodlands.
I can never say it never happens, but it's not a big problem for us. But what we have done is we've designed a closed visits room, which we haven't had before, to accommodate the change in population that we have. But we only use it in extremis. And that's if we do have, for example, reason to believe that there may be substances of any kind passed, because we don't allow tobacco either into Woodland. But we would only use that if we had a real and genuine belief that something was going to be passed to a young person. But we encourage family visits in open rooms, supervised by staff, obviously, but we want to keep that family link for the young person with visits, etc.
But if there was a difficulty, I suppose what I'm driving at, if there was a difficulty with drugs and a young person or young persons, you would be aware of it?
Yes. The Woodlands regime is set up so that there is a wide range of security cameras, close supervision by staff in the houses. I know some of you visited and saw the actual layout of the centre itself and the way in which staff are able to supervise the young people very closely. So yes, we will become aware of it very, very quickly. Be able to deal with the issue very, very quickly.
What's the ratio of staff to young people during the day and at night time?
In Woodlands?
Yeah.
Woodlands depends on the population. The policy has been that I'm staffed to have around an average of 36 young people. For example, today when I have 39 young people, the ratio of staff to young people will vary slightly. We do aim for half a member of staff to be available for each young person.
Half a member of staff?
Yes, but in reality it usually is one member of staff per young person with the staffing.
And would you have those figures for Hydebank Wood?
I don't personally have them, no.
Okay, thanks, Chair.
Mr McCarthy.
Thank you very much. For your presentation, you're saying that there's going to be one new order in the future. What's the timeline for bringing that order in?
Subject to committee's views and other steps that we need to go through, we would like to put the provisions into the Fines and Enforcements Bill.
So that's going into the Fines and Enforcements Bill? Okay.
At the moment, the Fines and Enforcement Bill is predicted to come in before the Assembly in the autumn.
And this is a sort of broader question, I might be for yourself, Paula. And just in relation to, have you noticed a change? You know, like obviously the last 18 months, and I think it's a good statement of our intent when the exceptionality clause is being removed. I think it's a good indication of where this is going. But have you noticed a difference in terms of even like working with young people in terms of outcomes in recently as perhaps it was in the past?
The agency has always worked with the young people since 2008 when 17-year-olds became young people in accordance with all the principles. So my staff are familiar with working with that age range in any event. And I'd like to commend my staff for the very hard work they've done to ensure we keep the ethos and regime of Woodlands maintained and run in the same way that we always have, with a social work ethos and a restorative ethos towards working with those young people. And the staff and the team there have worked very, very hard, and I think the Minister's acknowledged this, to ensure that we keep that regime going and we do the right thing. But we have had to look at our medical needs and we have had to look at our educational needs for that age range of young people that we now have, because as I indicated, the demographic has changed within Woodlands and we are largely seeing that age range either on remand or on sentence with us in Woodlands. So we have adapted to that and we are working hard to make sure we've got absolutely everything we need in place so that we can cope with that.
And would you notice the difference between, say, a young person when you get them and they go out the other end in terms of education attainment and
Yes, one of the things we do is work very hard to ensure that they achieve some success when they're with us in terms of educational need. And you'll all be aware that even at 16, 17, the maths, English, basic teaching needs are still required by this age group. And the benefit they have of being in Woodlands is that they have access to that education daily in terms of achieving basic qualifications that are required even for low-level entry education employment. So we work very hard to do that, and we always have our celebration of success in December to acknowledge the certificates achieved and gained by young people. But it's also recognising that that group of people have vocational interests too that we can develop whilst they're with us. We've always had, as you saw when you were down, the mechanics qualifications that we achieved there, which we linked to maths and education, so the two are linked. We've always had the cookery and home economics skills, but we're looking at other skills that we can develop with the Belfast Metropolitan College to bring in what's needed to ensure that the right education provision's there for those young people, so that when we do return them to the community, that we're returning them with skills and hope for education and employment.
Okay. And when the young person leaves the Woodlands and goes on supervision, is it a good record of maintaining their
Before a young person's released, whatever age they'll be from Woodlands, there is a number of meetings that involve the family, the police, the probation service, ourselves, and the pre-release meetings are very detailed to ensure that the right packages are put in place for that individual young person as they leave Woodlands and return to the community. So the right supervision's there and the right people are involved in working with that young person.
And what about employment? Is there a good, if you like, record of young people getting employment? When
It's one of the things that we're looking at measuring this year in our business plan. It's always challenging when you leave a custodial environment, whether it be Woodlands, Hyde Bank or one of the other adult prisons. If you have previous convictions in the current job market, it's incredibly challenging to get past the first stage. But what we look for is placements, work experience, all of the things that we can do to try and facilitate and help with that.
Thank you very much, Chair. Thank you.
Okay, thank you. Other members?
Chair, just quickly, talking about the custody, thank you for your presentation and the supervision split. And you talk about the transitional arrangements, maybe moving someone who's over 18 going into 18 and a half. Would that last part of their sentence going over into the YOC, would that include, say, part of the community part of a sentence? You see what I'm getting at here, where they may not be going sort of more to the YOC, that they're more out in the community during that final part of their sentence? Am I reading this right?
They could well be. What we have said is that the custodial element of the order will be served in Woodlands up until the age of 18. If the custodial element of the order extends past their 18th birthday, an individual panel would be assembled to decide whether that young person was suitable to transfer to Hyde Bank or if they should remain in Woodlands. Regardless of whatever part, you're right, there could be someone who is 18 who is actually serving the supervision element of an order which they were given when they were a child.
The important thing is that while we've had the transition periods now without legislation, it's worked in a similar way in that if there is still a period of time to be served in custody, multi-agency meetings are held, including Hyde Bank Wood, to look at the move, to plan the move, and my staff still follow through with the move.
Those multi-agency meetings could decide which way the final completion of
For example, you might only have 2 weeks left to serve after your 18th birthday. There's no merit in moving to Hyde Bank Wood for 2
That's what I'm
weeks.
getting at. There's no point here.
I thought
And
that was-
it could be out in the community, decided by the multi-agency.
There would be, the release meeting would be, the decision would be, if you've still got a period of time to serve, then it would be a decision up to before your 18th birthday when you're going to move and how you're going to move. If you've got a small period of time to serve, it may be appropriate to finish your sentence.
There's no grey area here. What I'm trying to get at, maybe, but it could be sorted with the agencies and how that would be completed.
The judge will always set the period the child is to serve in custody. What is
Right.
where the discussion happens is towards the final part. If the child reaches their 18th birthday, that final 1 or 2 months of custody, the decision about where they should serve it will be decided by the multi-agency, but they will always serve the period assigned by a judge.
Okay. Thank you.
Mr. Dixon?
Thank you. I think by and large, Chair, all of the questions of detail have been asked. Would you describe Woodlands as a success?
As Chief Executive of it, yes, I would, yes.
Because I want to agree with you in
Thank you.
respect of that.
Thank you.
Certainly the story that we've heard here today is a very important one, and it highlights that the way in which we treat young people who are children, effectively still keeping them out of the prison service, and for me that is incredibly important. They're being given their absolute last best chance to gain those education skills, to gain the appropriate social skills to interact with society. If that's what you can achieve, and I encourage you in respect of finding employment. I think that there are, and I'm sure you do work with a range of people who give you training opportunities, and the area therein lies in terms of trying to encourage them to turn those training opportunities into actual real employment, because there's nothing like getting a job.
That's right.
To mark someone out as wanting to stay away from the criminal justice system. So thank you for the work.
Thank you.
Okay, thank you. Everyone's finished. Well then, can I thank you all very much for coming to the committee. We look forward to scrutinising this when it comes forward to the committee in due course.
Thank you.
Thank you very much. Okay, members, the issues there that will require legislative change will be in the fines and enforcement bill, which is supposed to be with us around the autumn time. So we'll get into the detail of some of the issues when the legislation or the bill comes out of the executive. Okay, item 5. Under the EU Directive on the Right to Information in Criminal Proceedings, which was adopted in May 2012, Member States must ensure that all suspected and accused persons are promptly informed in their own language, orally and in writing, about their procedural rights in cases where they are deprived of their liberty in the course of criminal proceedings against them. While Northern Ireland is already largely compliant with the directive, some statutory revisions to the current PACE codes of practice C and H, which deal with the detention, treatment and questioning of persons detained under PACE and the Terrorism Act, are necessary to fully implement the directive. Consequential changes are also required to the current Notice of Rights and Entitlements, which is provided to all arrested persons detained in police custody. And the Department is therefore proposing to make a stat rule, which is subject to negative resolution, to bring the revision to the code C and H into operation on the 2nd of June this year, which is the date by which the directive must be transposed. So if members are content with the proposed stat rule, then we'll ask the Department to bring it forward, otherwise we can seek more information. Needed? Content?
Content.
Item 6 is the update on the Department's future legislative programme. It's there in members' meeting folders. Just draw attention to a couple of items. The bail bill has been removed from the legislative programme for this mandate by the Department, given the current workload which they anticipate having to deal with, and also the capacity of Legislative Council to progress all of the Executive's other bills. We had written to the Department in April 2013 asking why the bail bill wouldn't be introduced in this mandate, given the draft bill had already been prepared by the Law Commission. The Department subsequently indicated that it did plan to introduce it in January of 2015, but now they've decided to remove the bill. The Fines and Enforcement Bill will be introduced in October of this year, and the Mental Capacity Bill is supposed to be introduced in January of 2015. And that bill raised last week in terms of clarifying if it would be brought by the Department. So if members are content to note the information by way of bills, and obviously there's then a whole raft of secondary legislation that the committee will need to deal with when it comes before us as well, we can note it. Item 7, correspondence. There's 13 items, and I'll draw attention to a number of them. Item 4 is a response from the Director of the Public Prosecution regarding recent sentences in animal cruelty cases, which members considered to be lenient, and the Director has confirmed that these offences do not fall within the statutory category of offences for which he can consider exercising his power under the Criminal Justice Act 1988 as being unduly lenient.
What would we have to do in order for that to be included?
I'm assuming it would require some legislative change.
Should we write to the Minister or the Department and ask them, do they propose, how could they propose to make that change if they're so minded?
Yeah. Well, if we write to the Department drawing this response from the Director of the PPS to the Minister's attention, highlighting the public interest and political interest that there's been in these cases, and if he can advise if there's any mechanism whereby changes could be made to give this power to the Director, we can do that. Yeah.
It works in I mean, I met with the PPS recently. It was a domestic assault, and even there, I think the previous bodily harm can appeal, but an actual bodily harm you can't. So it is a
tiered thing. And therefore, there's no reason why we couldn't request that the higher level animal cruelty shouldn't be moved up a tier. I don't know how you achieve that, but a request at least to see how they could consider moving it up the tier.
I'm just going to make that point, is because it's animals to be crude. I mean, you know, some of the vile things that have been done against poor innocent animals, you know, just because they're animals doesn't mean that it isn't evil. And I think really what Mr. Dixon just said, I think it's important that it is looked at much more seriously.
Yeah.
All right, well, we'll raise it and see what the response is, and we'll ask for what the criteria currently is.
Step it
For
up.
how you appeal.
How you
yeah,
appeal.
okay. Thank you.
Okay. Also then, on that animal cruelty, that's an issue for discussion with the Lord Chief Justice as well.
Yes.
When he attends on the 4th of June. Item 9's correspondence letters from 3 individuals about their concern in respect of the length of time being taken to review the position regarding the PSNI equal pay claim, asking this committee to write to the Department, the Police Board, PSNI and the NIO on the matter. So the Department intends to provide an update on the equal pay issue at the end of this month. So if we write to those relevant organisations highlighting these concerns again, and we can come back to the matter when we get a briefing at the end of May. Item 11's correspondence from Play Board Northern Ireland, providing information about its Let Us Play campaign, which aims to achieve improved level of recognition for the importance of play across government, wider society, and requesting a meeting with the committee to brief members. If members are content, we can set up an informal meeting at an appropriate time for them to meet with us. Item 12 is an invitation from the Pro Bono Choir to attend its Harmony for Hospice concert on Friday the 16th of May at 8 p.m. in Campbell College. Anyone wishing to attend, you can advise the clerk accordingly. Is there any comments on any correspondence I've left out? If not, we'll agree to action it as outlined in the meeting pack. I have no chairman's business. Is there any other business? All right, and then our next meeting is on Wednesday the 14th of May. It's in the Long Gallery, and it's for the evidence hearing to do with the Legal Aid and Coroner's Court Bill. Then the meeting will move to this room for a briefing from the departmental officials on the Fair, Faster Justice Bill if it's cleared by the Executive. All right.
Commencing the Long Gallery at 2, Chair, or earlier, did you say?
The first event's at 2 o'clock in the Long Gallery. All right, thank you.